Doctor, do you consider your chapter in this textbook to be authoritative? Oh, no, I don't. No, you don't? Really? Come join me as I share with you how this applies in a medical malpractice case. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now we're at trial. I'm cross-examining the defense's medical expert. And now I learned beforehand from doing my research that this doctor on the witness stand had authored a chapter in a very important textbook that doctors use often. So now I ask him, Doctor, your chapter, is that authoritative? And he turns around and says, no, it's not. Really? Your own chapter that you wrote, you're telling the world that your own chapter is not authoritative? That's correct. Now, if I were to ask him why or why not, he's going to turn around and say, because by the time I publish my findings, it's already out of date because it takes such a long time to actually publish. And that's why journals and peer-reviewed articles tend to be much more up to date. Now, you should know that in New York, when I'm cross-examining a doctor, if the doctor refuses to acknowledge that a textbook is authoritative, then I cannot use the information contained in that book in order to cross-examine him to show him that there's information here that contradicts something he's just testified about. That's a very interesting ploy to use. You should know that every single defense doctor does that, as well as the plaintiff's doctors as well. But this is really important. So now I have to show to the jury that this is ridiculous. It's a ridiculous argument. Doctor, are you telling us that the information contained in your chapter is not valid? Oh, no, that's not what I'm saying. Well, I asked you whether or not this was authoritative. Is this an authority at the time that you wrote it? No, it's still not an authority. Why not? And now, again, I don't want to ask a question to which I don't know the answer. And doctor, isn't it true that as an attending physician in practice for 20 years, you often refer to this textbook for your own purposes? Isn't that true? Yes. And when a doctor asks you for a resource to learn information about this topic, isn't it true that you tell them to go to this textbook? Yes, it is. So now I'm letting the jury know that this is a very significant textbook. And the magic words that the doctor doesn't want to acknowledge, that it's authoritative, is preventing me from opening up to page 27 and say, Doctor, isn't it true that in this chapter you wrote the following thing? But yet you told us just a few minutes ago just the opposite. There may be certain opportunities during my cross-examination to use selected portions of what the doctor wrote in his own chapter against him. But it's going to be quite challenging. So why do I share this great information with you? I share with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.